Here we are, the Unnumbered Man Rumble channel, Unnumbered Man Rumble channel. So here I am, David Alan Carmichael. I'm here to talk about our case in the federal court. It's a case about trying to get passports without social security numbers. And in our case is we're semi-successful so far. I think we've been successful in helping a whole lot of people get their passports, and ours are still troubled, and our case is still troubled. And so I wanted to tell you about it, give an update. And again, if you never, if you're looking to this, is really weird. What's this No-SSN passport stuff? Well, this is part of a series of videos that I intend to do on Sunday nights at 9 p.m. Eastern, where I give updates on our case. And then as we go along, there are hopefully some of these Rumble broadcasts here will be things where I can actually equip somebody who's coming after me and to show them the things that we've learned as pro se litigators have had to go into this litigation to get our passport problem solved. And again, if we were trying to do it with a lawyer, it'd be I'm thinking well over $100,000 so far of what we've done. And the other thing is, if we had a lawyer so they could save us money, they would be compromising our stance. Instead of holding the government accountable to the law, right? Isn't that what we're accountable to, the law? Instead of doing that, if we had a lawyer, we might meet them halfway. So they would stand 2 steps into Hades, toward Hades. We'd be standing on the truth. And if we had a advocate, they'd be asking us to step halfway to hell. And so that's something that we can't do. And again, one of our fellow now appellants, Larry Lewis, I was talking to him last night, and he was quoting scripture. And off the top of my head, I can't think of what it was, but it was basically Old Testament talking about, if sort of like James 4:17, if a man knows a good he ought to do and doesn't do it, to him it is sin. It's pretty much the same thing. But it was in the Old Testament. What it was who would be held accountable? I'd be held accountable. In fact, I'd be agreeing with a lie if I didn't try to get the government to behave themselves, to correct their misdeeds, to hold them accountable for their misdeeds, to get it on the record so that they would be much less likely to do this again. So what I'm going to do is, because this is a series, I'm not going to tell you the whole issue of the case. What I'm going to do tonight is, as it says, as the marquee says, No-SSN passport case, government scrambles to divide appellants. That's the hook. Government scrambles. I think the hook is No-SSN passport case. I mean, for most people, that's kind of weird. I think there's going to be some intrigue, even if you've never delved into those issues of life without a number. But then the secondary thing, obviously the subtitle, Government Scrambles to Divide Appellants. That's what we're going to be talking about tonight. And I'm going to go through actually, so it's going to be it's always going to be sort of academic. Hopefully in the midst of it, we'll have some entertainment at the very end. So once we get through this structure that I've laid out, where I'm going to show what the government proposed, see their scrambling, and then see what the appellants that were on record at the time responded to. And then we're going to look at, I think the third thing was a motion for electronic filing. So there's some procedural things that people can learn from us as we're stumbling along in this. Oh yeah, I think the third thing was the court actually on its own motion did something, and it was a little premature. Maybe had they read what was coming to them, had they waited more than a week to act on what the government submitted without waiting for us to respond, our team anyway, if our team needed time to respond to the government motion, and then let the court do what they were going to do. But the court kind of jumped the gun. So we're going to look at how they jumped the gun and see what kind of had to be said in the next document that was submitted. So you're going to you're going to be able to observe the litigation while it happens a week at a time. I hope there's a benefit that it's edifying and educational and hopefully inspirational. So that's it. So I'm going to proceed with this. I'm going to see if I'm going to track my own. I'm supposed to be watching to see if there's any kind of chat or anything like that. So, but I've got one of the things with my phone has this, it's got the situation, the security thing set up so that it will shut down about every 10 minutes, and I haven't been able to fight that. So we'll see what's going on there. If I can go to chat there's live chat. So I've got chat available, and I think I'll push this button every couple of minutes in case somebody checks in. That way the security feature won't kick me out of here. So here we go. We're going to go and we're going to turn on the government document and turn off my presentation. And right now, there it is, the government document. So here it is. This is the government's document. And let me switch to that page to see which one it is. And so I can scroll through and actually read the silly thing. So here it is. It's oral argument not scheduled. Well, that's good, but we'd like to schedule one. I think they're trying to sell that point here. So here's our case. Currently, what we're looking at here is it says Rick Dale Hollingsworth, movement appellant, Michelle Bolton, movement appellant. What happened is we had sued the Secretary Pompeo, then it got substituted by Mr. Blinken, and we sued because they were denying passports to us, notwithstanding that we asked for a religious accommodation, and there's all these laws that protect that, and they just completely ignored it and stomped on us until we sued them. Basically, you can't have a passport unless you sue us. That's essentially what was going on. So then what happens, they say, well, we're going to wait long enough for one of your people to die, and then other people are going to get beat up. While we're promising that we're going to give you a passport, we're going to be mean to other people who aren't in this case so that they'll have to sue us. And then if they'll sue us, then we'll give them a passport. Well, that was kind of going on. So, and there was a point a year ago where they kicked us, sort of half of us, out of the case. So the people that they kicked out of the case was Rick and Michelle. And what they did, we all together filed a notice of appeal because I believed our case for me and Larry was just part and parcel with what was going to Rick and Michelle. It was already a done deal. So we did an interlocutory appeal saying, they haven't stamped a denial completely on us yet, but they might as well. They've already put all the writing on the walls, and we need intervention now so we can get this case kicked off. So we did a motion for interlocutory order, and the circuit court of the D.C. Circuit said, no, David and Larry, you are still an active participant there, and effectively William Pecos, deceased, is still there. But we will accept Rick Hollingsworth's appeal, or his movement, and Michelle's motion, as something that is actionable in the Court of Appeals. And so what happened is they just kind of held on to their case until Larry and I just finally recently were dismissed. So this is what happened. We filed our notice of appeal. So we got our case dismissed finally March 20th. And so we had 60 days to file a notice of appeal. On May 15th, Larry and I filed our notice of appeal, and we did it electronically because you do the notice of appeal in the district court, and we had permission to file electronically. So as soon as we push send, it's on file, and immediately the government gets notice. The very next day, our observation was in response to our Larry and my notice of appeal. They did a motion that's basically said, as you'll see here, and I'm going to skip ahead a little bit. They're basically saying, hey, Michelle and Rick have they've already made their briefs and everything. Go ahead and decide to get rid of them before Mr. Carmichael and Mr. Lewis show up. So look what it says here. Proposed response. As movant appellant Michelle Bolton, her appeal from the denial of her motion to intervene as of right is fully briefed and ripe for review. And they said the same thing for Rick Dale Hollingsworth. So it says William Pecos is deceased. He's not a party to this appeal. So it says it's been fully briefed and ready for disposition. It says the March 2023 order, that's about me and Larry, doesn't have a substantial impact on this appeal, and rebriefing is unnecessary. So we actually respond to this. Michelle did, and Rick did, and then Larry and I kind of joined it, right? Like, hey, we want to come play with these guys. And you'll see how that works out. But it says rebriefing is unnecessary. You'll see their cases are completely linked with our cases. Right? It's so, as our observation, we see the government scrambling. Right? It's just kind of silly. So we're just going to continue on to see what their argument is. And if you have any questions or comments, you can put it in live chat. I see 2 people are in the live chat. And I don't see any chats, so people are capable of doing a live chat. If you've got a question, put it down on chat as we go. Okay, so here's the government statement of the case. And again, the tough part is it's kind of technical. Try to keep it light. On December 7th, that's a day that'll live in infamy. They just go on to say here that Michelle and Rick put in their appeals, and they go into detail there, which I don't want to go into. Because basically, I'll summarize what it says. It says it reminded the court that Michelle and Rick are an appeal, and Larry, in my case, got stuck back to the district court. So, and then it goes on to the deal, onto what was being, let's say, what they thought were issues on appeal. So what Michelle had going was she filed for a passport, knowing and watching our case, knowing that the government said to the court, we plan on giving Mr. Carmichael and Mr. Lewis and Mr. Pecos a religious accommodation. And that's all they did. They were like, someday we intend to do this. So kick their case out because we intend to do the right thing someday. That's essentially what they were saying. Or essentially what they said. So Michelle, knowing that, files for her passport renewal without an SSN, just like she'd been doing for decades. And they told her no. Too bad, so sad. So she reapplies and says, wait, here's what they said in the court. They're giving an accommodation to this stuff, right? So I hope this Rumble thing's actually showing my video, because on my phone I'm showing nothing but the outline. So if you're seeing my face, please send me a chat, because on my screen I've got streaming. I'm showing that I'm streaming actually my face and not just the preface there, not just the marketing thing. So either way, if you're listening as if this is a radio show, I'm going to press on smartly and find out what it was I was talking about here. Okay. So Michelle said that, and the government was still denying her passport, even after she quoted our case showing what the government was promising. They still denied her passport. It was not until she sued them and said, I want to intervene. I want to join this or intervene in the Carmichael Pecos case. And what Larry and I, and Pecos, William and Larry and I moved to join her because we believed it was better that she was joined to the case because her situation was the same injury that we were suffering. And until they did that. And then even when she files suit, they say, oh, she can't file suit because we haven't denied her request for accommodation. What a bunch of liars. What an absolute brutal lie. So eventually, after they couldn't put it off any longer, they issued Michelle a passport. And then, nothing to see here. Send her away. Her case is moot. So she's like, no, it isn't. You've injured me. a bunch of times, not only the first time you denied it, but then the second time you denied it. And then the third time after I filed suit, you're still doing wicked things that have kept me in, figurative and literal chains. Unable to travel, right? And oh, by the way, part of your lie shows that you did this to me a year ago. And somebody needs to be sued. But the thing is, she had already had her complaint in. And there's these new things needed to be added. So it's kind of a technical argument. So here's what the government said. As soon as Larry and I filed notice of appeal, May 15th, May 16th, this is what the government's scrambling to do. They says on March 20th, they dismissed my case and Larry's. And it said it makes an accusation of what the court found. And we are contesting that even. It says that following the district court's final order, a special of this panel of the courts directed the parties to file motions. Now I'll tell you what. So what happened? Here's what happened. As soon as the appeals court saw that Larry and I were dismissed, what they did was they kicked Larry and I, or they saw that Larry and I were dismissed out of the district court. They understand we've got 60 days to appeal. I think they were anticipating we were going to appeal. And then what they did is they added 30 days onto that 60 days and gave a forecast date that motions need to be submitted. So they said, by June 20th, if these guys got appealed by May 19th, then we'll give you till June 20th to get motions in. And that's the normal schedule. If you look at the rules of appellate procedure, so the court is already waiting for Larry and I to finish with the district court and come hopping in. That's what was going on. So here's the government going, no, with this motion here. We don't, no. Judge, convene now. Get together this week and kick Michelle and Rick out of the case before Larry and David ever show up. So it says the court here should decide the appeals of Bolton and Hollingsworth, which have been fully briefed and are ripe for a decision. Pecos is not a part of this appeal, even though it's named after him. Hollingsworth's arguments on Pecos' behalf were improper. And so it's just saying that the Pecos matter that Mr. Hollingsworth is trying to be the substitute is completely nothing to see here. That's kind of their speech. And then it's, okay, so finally deciding this appeal at the court's earliest convenience, now would serve the goals of judicial economy. Okay, now here, folks, we're going to go on a civics lesson here. What is the purpose of government? Judicial economy? I remember George W. Bush saying, government has been called for these purposes, to spend the people's money wisely. That was one of the things he said. The purpose of government is protect our life, liberty, and property, right? And that's our pursuit of happiness. It's not judicial economy, it's justice. But their heart is corrupt. Their perspective is corrupt. And so it is our duty to use the process to have a concrete connect the dots procedure for the government to follow, because if they follow their heart, which is desperately wicked, and who can know it, they're going to reap destruction under the guise of judicial economy. So it said, be judicial economy to dispense with their case as fast as possible and be inconsistent with a bunch of junk. Therefore, the court should consider the appeal submitted and render a decision on the existing briefing. It's divide and conquer. That's what they're doing. So the appeal from the denial of Bolton's motion should be decided. So they talked about Rick Hollingsworth half, and then they talk about Michelle Bolton's half. And without going into detail, I wanted to show you the government is saying, you have the paperwork for these two, don't look at the other two. So and I don't want to go into the argument per se. So Hollingsworth's appeal from the denial of motion should be decided. Well, okay, that's true. Pecos is not a party, has no appeal. So this is something that we did. We realized, well, wait a minute. William Pecos is still in the case with Larry and I. So Rick wants to be a substitute. Somebody's got to move on behalf of William's interests. So not knowing what we're doing as pro se litigators, you're going to see we attempted to do something about that. But I've got 3 people that are available for live chat. I don't know if this is actually showing up. If my video is showing up, I have no idea. Look what it is I'm looking at. A blank screen with just the header of the entertaining, the topic, right? I don't know what's really showing on this screen. So I've got 3 live chatters. Please chat. Tell me if you're listening to this like it's a audio podcast or whether you're actually seeing a live stream. I need to know that. Now, I did choose podcast, so maybe audio is what it is. Somebody just dropped out. So what I'm going to do next is, what's good about this, I'm recording this on video, so it's going to come up to Rumble one way or the other. Might end up on some other platform. So what I'm going to do next is, so you see what's happening is the government is scrambling to try to divide and conquer. That's my language. And then so what we're going to see next is we're going to see what was the response from the parties, the appellant parties, to see how they responded to that. So the response is, it is United States District Court, and the cover says Pecos et al. That's the name of this case, and under this 22-5143, and then Blinken and a plaintiff appellant scheduled proposal response to defendant's appellee's motion to submit appeal. And we have oh, by the way, the government, without showing you, the government actually, if you read their stuff, they actually cited 2 cases in footnote. And they said, well, they've already, all this stuff has been waived or whatever. And what it was a 2 cases where the parties had voluntarily done a stipulated dismissal. That has nothing to do with what happened in Larry and myself. It was against our will, not voluntary. We went kicking and screaming, etc. So this is what we did. So Michelle and Rick are responding to say, hey, no, you're not just going to decide this. Our cases are so linked with Carmichael and Lewis and Pecos that you can't just dispense, because if they have a case, we have a case. You don't decide we don't have a case before deciding they don't have a case. So that's sort of what has to happen here. So let's see. So what happened is now Larry and me and Rick, on behalf of William Pecos, have got to join Michelle and Rick's proposal as Michelle and Rick. So here we said, we, David Alan Carmichael, Lawrence Donald Lewis, and Rick Dale Hollingsworth, as substitute for which William Mitchell Pecos. I moved to be an alternate as first friend. Rick as first blood. Appellants who originally petitioned hereby join the proposal that Michelle and Rick were submitting. So we added that, and then there's a statement of oral argument. Now here's something for our education. Oral argument in the rules of appellate procedure is not allowed to people that represent themselves without a licensed attorney acting on their behalf. So it says, in the ordinary course of scheduling, we can forecast there's a greater likelihood we can find a lawyer to assist us in that time. And we're looking. We have somebody on our radar scope. Our tracking radar has not honed in yet, but we're observing on our search radar, and we've got a contact. So, oral argument is preferred, and it says they don't allow us pro se untrained litigants to do our own oral argument. So, getting a lawyer who can advocate for us is necessary. We object to the government appellee's statement regarding oral argument, the lack of comity prior to their motion to submit in lieu of a schedule proposal as ordered by the circuit court. So they should be talking to Michelle and Rick and saying, what is your proposal? Would you like to get out of court really fast? And they're claiming that email constitutes service of process when electronic filing is barred to us. So that's an objection in Michelle and Rick's document, because they said on their certificate of service, the government did, we emailed them service. That's not service. When the appellants aren't allowed to do electronic filing, you don't get away with service by email. You don't. So I don't know what was going on there. So here we go. Are you ready? This is educational, a little bit dry, okay, a little cerebral, but you're observing us pro se litigants suing in a civil suit against the United States, who's using taxpayer dollars to make sure our life, liberty, and property are in jeopardy. That's what we're observing. They're fully paid, fully equipped, fully funded to do this. We are not. But we have a duty to hold them accountable for the misbehavior. And what we're doing is we're learning as we go. So let's share it with somebody else. Maybe you can learn as we go. Maybe you can see some things we stumble on while we're stumbling. And then if you get in a situation where the government bulldozer is trying to kill you, try to wipe you out, to make you ineffectual in life, to make you not travel, whatever it is they're going to do, and you need to stand for yourself because there's nobody else to do it, you can watch this video and go, and maybe as the stages progress, you go, oh, I see what they did, and that was really dumb. Or you'll go, whoa, I'm glad I saw this video. I'm so glad they did that, because I would have never thought of that. So, the four of us, as we plod along here and we consult with one another about what we should do next, you'll get the benefit. That's what we're doing. We're making disciples. We're training our relief. So this is Michelle's response to the government saying, let's get Bolton and Hollingsworth out of this case as fast as possible. Don't let Carmichael and Lewis and the Pecos matter get back together with these guys. So it pointed out that March 20, Lewis and Carmichael got dismissed. And it points out that 1 week later, having its eye on those district court proceedings, the circuit court issued an order for the parties to file motions to govern further proceedings by June 20th. In light of the district court's order dismissing all remaining claims, we can reasonably assume that the math determining June 20th deadline calculated 60 days for a notice of appeal deadline and 30 days following that as the ordinary deadline for motions. So this is a sound, just ordinary human being talking on paper. We intended to wait for Carmichael and Lewis to meet their notice of appeal deadline before discussing with all parties what sort of agreed upon schedule we should submit as a consolidated proposal in response to the circuit court's sua sponte order. That means sua sponte, it's spontaneous. So they saw the dismissal and they spontaneously, with nobody's motion, gave a scheduling order for basically telling this case in the Bolton Hollingsworth appeal what their plan is, because the court's anticipating that Carmichael and Lewis and Pecos case is going to be arriving soon. So there's an objection. Object to the appellees filing their proposal without a meeting of the minds, and we object to the substance of what is a motion to divide and conquer in the name of efficiency and economy. Whew. Okay, statement of the issues. The reason Carmichael and Lewis was dismissed was because district court's order. Okay, so it goes back in the history, and it says the gist of Bolton's dismiss motion for intervention and the motion for joint. Okay, so what, as I said, it's reiterating here that that Bolton tried to intervene in our case, and we tried to join her because they were so similar. It wasn't just she had interest. I mean, it was just completely parallel. It says with the Carmichael and Lewis notice of appeal, the case in controversy is still alive. Bolton's case is inextricably entwined with theirs. Bolton's case pointed out there are other concrete and actionable injuries subsequent to her filing to intervene and join that need to be adjudicated. That's a big word. The fact that Bolton's rights were violated by defendant appellees after the government promised the district court that they were going to accommodate religion for the three men, and that the officers repeated the wrong against Bolton after she pointed out the government's promise to the court regarding accommodation, is part and parcel of the three men's argument as to why their case is not moot under the principle of their case evading review. So don't want to go in those details. You can read about that in law books. Pecos' case is not moot if there are monetary damages, relief for his, Carmichael's and Lewis's unlawful seizure. Now watch this, guys. So if you've never heard this term, as we were typing this, I'm going to tell you a little bit about this. As we were typing this, and something occurred to me that I remember reading in Blackstone's commentaries on the laws of England. And there was this writ ne exea reina, a writ that says you're not allowed to leave the kingdom. And as we're talking about it, and I'm starting to type a paragraph, all of a sudden I did a search. I was trying to find out where it was in Blackstone's commentaries where I'd seen that. And what pops up? A law in the tax law called writ ne exea republica. And that is a full due process IRS thing where they file suit against you in the district court to get a district court to find that there's enough evidence to show that you owe so much tax that the court should issue a writ that prohibits you from leaving the kingdom. That's what would prompt a canceling of your passport. But it's full due process. They have to attack you. You get to defend yourself. And they have to prove, they got the burden of proving that you've got so much excess debt toward the IRS that there's a danger of you skipping out on it. They've got the burden. And then you get to defend it. And then based on the facts and the law, then after full due process, you get writ ne exea republica. What they did here is say, well, if you won't confess an SSN as an element of your identity, you get a writ ne exea republica. You're presumed to be wicked. That's what was going on. So, and that's false imprisonment. And we claim damages up to $500,000. But the court can, if they have a real trial, can taper that back to even one, which I think it'll be an injustice. But nonetheless, there's relief available. We still have damages. That means the case is not moot. Pecos, though he's dead, he and those who would inherit from him, he has a property right and at least $1. Pecos' case is not moot if monetary damages, relief for his, Carmichael's, Lewis, unlawful seizure by writ ne exea republica without due process. Rick Hollingsworth has presented himself as a common law replacement, substitute, his first friend / blood. He's the son-in-law, but out of this family, they decided he was the one that was most aware of what, and talking to William as it was going and was able to represent the family interest. Carmichael moved as the alternate substitute as first friend because I got my passport revoked because of Pecos. They retaliated against me because I was helping him. So I was first friend. Don't be punching me in the nose and then say because I helped him, and then say because because it was you that helped him, you're not allowed to fight on your own behalf with regard to what's relevant in his case. So Carmichael's injury came as a result of retaliation for his administrative assistance to Pecos. Pecos' case remains intertwined as it had been from the beginning. Pecos had joined with Lewis in their demand for a finding of fact and conclusions of law. So this is what happens. I won't even read the whole thing. No, I'll go ahead and read it because then you'll get the summary by actually hearing what's going on in the case. I hope you're getting something out of this. So Pecos had joined with Lewis in their demand for a finding of fact and conclusions of law regarding the government's stall and continued seizure by way of frivolous remand motion without going into the details. Instead of having discovery and starting to expose the lies of the government and find out who did what, when, why, and how, instead of going with, we can't sue customer service department. We don't know who that is. But somebody was wicked. Instead, and in fact, as soon as we won our first, survived our first motion of dismissal, they should have issued passports like that. Voided the revocation of mine, issued Larry and Williams. They should have done like that. But instead of that, they stalled. Well, let's see what we can do. They said, well, see if we can do an accommodation. You already accommodate. If somebody would sign an affidavit that they've never been issued an SSN, you'd have issued a passport. Right? And we said, our declaration, we want to be a little more correct in our declaration. So we gave them a real live declaration that actually talked about our religious convictions about the whole thing. Ramp it up a bit. So, and there's statutes that protect that. But instead of doing that, they said, well, we're going to lose. The government was going to lose. So they made a motion for remand. Now, normally, so they're treating it like it's an appeal from the administrative agency. But normally, the whole record is supposed to show up in the appeal court. Whoever's reviewing their decision, the record's supposed to be there. So there's accountability. And the judge can scrutinize what they're doing based on the record, based on the regulations that control their decision. But none of that happened. There was a one-sided discovery. They said, well, if Lewis and Carmichael and Pecos will give us whatever we asked for, then we'll give them a passport. No, that's one-sided discovery, friend. Not going to happen. So they did this remand, and then in response, Larry and William filed a motion. Hey, court, you're doing something that there's no provision in law. You're actually doing an injustice. Show us the facts and the law that support your order to remand us back send us back into the lion's den. By what authority are you doing that? Guess what? So the court, knowing that all it has to do is stall for this order's period of 90 days, when it's over, their motion would be moot. Oh, time's up, which is fine if it's not injuring you. If at the end of that time it didn't injure you, it's moot. However, what the judge did is he relied on that, what he ordered to happen, as having some real legal merit. If he hadn't relied on it having any merit, wouldn't have a problem. It was just a little bit, we need to get paid more damages because you've kept us in prison an extra bogus 90 days. But so what happened is it was a bogus remand, and they demanded that the court tell us why you did it, and the court just ignored them. So Pecos and Lewis were also joined in their demand for district court to compel the issuance of their pass. Okay, so this is what happened. You'll read it. I'm going to tell you what happened, then you'll read it, and it'll make sense. So during the remand period, they've got to find some excuse, one, to show why the remand is legitimate, which it wasn't. And they've got to get us to participate in it voluntarily, because as soon as we volunteer in the remand, our passport case is moot. Our initial applications are moot. If we voluntarily partner with this fake process, we've voluntarily forsaken the law. So they said, well, we need a new photograph. If you'll give us a new photograph, then we'll issue the passport. No. That's under the guise of this remand. We're not going to participate in the remand because it's fake. And we can't get a benefit from your fake remand and complain about it at the same time. We'll abandon our complaint. We've got to stand on what the law is. We got to stand solid ground. We got to stand rooted in the law. No way. And then so Larry and Williams' passport, watch this. This is great. Larry and Williams' passport at the end, on day 89, they wrote a letter to Larry and Williams saying, your passports are denied for a non-religious reason because you didn't literally said the word voluntarily give a photograph. Well, we said you don't need a photograph. When we gave you a photograph with the application, it's a 10-year photograph. It's only been 3 years. You got a regulation that says, okay, you've waited 3 years. Give us a 7-year passport. The photo's still good. It's still good. There's nothing wrong here. Sure enough, they said, well, based on this regulation, read the regulation agreed with us, right? It totally contradicted everything they said under oath. It was sick. Sick. So after that happened, they said, wait a minute. You owe us a passport. Quit goofing off. The law supports us. The regulations support us. Your photograph regulations, your foreign affairs manual, 110% agrees with us. And you're a bunch of liars, and we can see it in writing. Issue the stupid passport. So they made a motion for the court to order the government to issue the passport. The government and the court said, nah, you didn't give me enough evidence. No, I'm not going to give an order. Okay? So it didn't have a finding of fact or conclusion of law. See, what the court is doing is they're trying to make sure there's no judgment in our favor. That's what happens. If they had given that order, they would have had a finding of fact and conclusion of law that we're 110% right, and somebody in the government's been misbehaving over and over and over again. So they had to sweep it under the rug. No. We're not going to compel it. And the court's figuring, well, these guys are eventually going to get their passports. If I can just stall long enough, those even if they're a knucklehead, eventually somebody in the government is going to have enough sense to give these guys a passport. Hadn't happened yet. The writing's on the wall. They owe us one, but nobody's stepping up to do the right thing. So this is where they said the district court denied Larry and Williams' motion without a finding of fact or conclusion of law, keeping them in a status of written exeat republica unlawfully throughout the remainder of Pecos' life. Yet without a finding of fact or conclusion of law, district court ordered the government, defendants appellees. So at the end of this, I forgot to tell you. So they moot Larry and William on the basis of, we denied you for a different reason because you didn't give us a photograph. Now, just to let you know, Larry's and William's photograph was newer than mine. And they sent me a replacement passport, though my photograph was older than theirs. Though a replacement passport requires a new application. It doesn't, they're just scheming. Why can't you just obey the stinking law? It's like what's the word? Anathema. It's like it's unholy to them. They believe they're doing the holy thing is to not obey the law, to not be a minister of God, to not have a ministerial capacity and just do what they're supposed to do. That's what we're observing. So they approved, technically, they make like they approved mine, and which in an unlawful way, they're inviting me to participate. They're giving me seditious communications to invite me to participate with their unlawful conduct. I'm not going to do it. And they tell these guys, oh, your stuff denied. It was unlawful, but they denied it. So finally, I think it was, I'm trying to think what year it was. So last year was 2022. In 2021, we objected to the court kicking out Michelle and kicking out Rick. And we pointed out these guys still haven't given Larry a passport, even though there's no excuse not to. They promise that someday they'll do it, so our case is moved. Someday we'll do it. Kick out their case. And the court, we pointed out, someday when we grow up, we might have a passport based on the promises of the U.S. Attorney's Office. Never seen anything from the State Department saying that was the case. So this is what happened. The judge, without a finding of fact or conclusions of law, for the very intention of taking over the case for the U.S. Department of Justice, orders the State Department to issue Larry a passport, no finding of fact, no conclusion of law, no motion. They'd already given a motion. Give me a finding of fact, conclusion of law, and order compel them to issue the passport. So they order them to issue the passport to moot Larry's case. I'm not a lawyer, but you know what? You ever heard that term, abuse of what is it? It's not prerogative. It's not abusive process. Discretion. Abuse of discretion. You have no discretion. You have no discretion to do what you did. So we're going on appeal. So yet without a finding of fact or conclusion of law, district court ordered the government to issue Lewis a passport to enable the government to fulfill the court's order to make a motion on mootness. They took over the DOJ case is what the judge did. So ending Lewis's 3-year stint of unlawful seizure without relieving him of the hurts from his injuries. The relief due Lewis, now this document is going to the appeals court in response to the government saying dispense with Bolton's case, dispense with Hollingsworth's case, don't look at Carmichael, do not look at Lewis. And this response of government is, no, like David said to Goliath, is there not a cause? Who are these uncircumcised Philistines that mock the armies of the living God? Is there not a cause? Neither Bolton, Pecos, nor Hollingworth case are ripe for adjudication in the circuit court till Carmichael and Lewis have had their unrushed chance to file those documents required of them in the ordinary schedule promulgated by the Rules of Appellate Procedure and the court's order of May 17, 2023. Contrary to the government's statement on page 1 of their response, the March 20 order does have a substantial impact on this appeal. That substantial relevance justifies the circuit courts taking notice, so they took notice of the March 20 order from the district court, and putting in place a deadline, pudding. Is that putting or pudding? How do you spell pudding? Okay. In place, a deadline for a schedule motion in sync with the schedule laid out in the rules for Carmichael and Lewis is consistent with the court order, blah, blah, blah. Okay, that's a little detail. Government appellee's proposal does not serve the ends of judicial economy. It only serves to have a disjointed review of cases that are intricately entwined. Their cases cited are off-point, voluntary dismissals. We waive nothing. This schedule is not the place to reform our briefs. Now that, you'd have to read the government. Okay, that's alluding to something that was in the government motion. In accordance with the circuit court's ordered schedule, blah, blah, blah. So what had happened is the circuit court, when Larry and I filed our notice of appeal, the circuit court issued a schedule. And this is like exactly in compliance with the rules exactly, but it all works. Basically, they give you 30 days to get in all these things. Entry of appearance, docketing, schedule, stuff like that. Maybe in a future video cast or whatever, we will be able to talk about those things and maybe someone will get a benefit. So having mutual interest in the case Carmichael, Lewis, and Pecos, we invite them to join this scheduling proposal. And that's what Larry and I and Rick did. Rick on behalf of William Pecos' interest. So we joined. And so Michelle and Rick say that they are inviting us to join this response. And look at the conclusion. The two cases need to be consolidated. And they signed it. This is the copy I got from, I think I got this from, I'm not sure who, I guess I got this from Rick as it was going to Michelle for her signature. And then there's a certificate of service. So if you'd like to know about that, someday we can talk about that. But I'm going to continue on. And if you have any questions or comments, those of you who got an email can give me a call. If you want to put something in chat, I'm trying to get live chat here. And if nobody has told me yet whether this is actually being showing on video or not. If this is just an audio podcast, because I'm learning Rumble right now. And I think I put it as podcast, not knowing if it was audio or not. So just to know, I'm recording this on video. It's going to go up on Rumble on our channel in video format, and you'll be able to see these documents. So here I go. So the next thing I'm going to do, in our list of the things that we put on the list of things that were going to happen, I mentioned the third thing was the circuit court. And I haven't called up a copy of that document, so we're gonna miss that here. So Word document here, redacted. Oh, here we go. So what I'm going to do is I'm going to talk about joint electronic filing. So what I'm going to do is I'm just going to talk about submitted proceeds, decision appeal. Okay, I got to turn some of this stuff off. That's a government motion. Here we are. So I'll explain what happened. So Michelle puts in the proposal. Before she could get the proposal in about what the schedule should look like, the court, on its own motion, consolidated the two appeals. But when we looked on the when we finally figured out they did that, and we kind of, a week later or whatever, saw the docket, we saw that Michelle's name wasn't attached to the consolidated case that the court did. They consolidated without us having a chance, or Michelle having a chance and Rick having a chance to respond to the government scheduling motion. The court, on its own, consolidated these things, but left Michelle out of it. So likely, after the Memorial Day weekend, there may be some sua sponte behavior by the court, or I think the government has an opportunity to reply. Hopefully the court will wait to see what the government does in reply before they make their own motion to start juggling the consolidation. We'll see. So it's a little confused. So so we're going to change the subject now. In fact, I think I'm going to do a new video. I'm going to take out 10 minutes, and maybe by 10 o'clock Eastern, I'm going to do a video specifically, just to see if this video thing actually worked, on filing for electronic, making a motion for electronic filing. So thank you for watching, and I'm going to tune out, and I'll be right back in a few minutes with a live. I'm going to make sure this is a live video stream, and we'll be right back.